The law understandably didn't want, notoriously, it would be men who would sometimes be angry at their wives, and they'd have a will, and they could leave everything to their kids or to their girlfriend.
Yeah, the girlfriend.
To the girlfriend. And so you have this wife who may have been without means to make a living, and all of a sudden she's broke.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
So we're back. We're back for episode 2 of our discussion about death and divorce. So I hope that you found episode 1 exciting. I think that you will enjoy 2 and what will be 3. We're doing a total of 3 on this subject, but it's just rich with, in my opinion, useful information for many people who have either contemplated divorce, you're in divorce, or maybe you've just recently emerged from divorce. We think that this is really important information that sadly I don't think is available anywhere else. So welcome. We'll pick up our conversation from episode 1. Enjoy. The person who wants to do estate planning, these are the sorts of opportunities. And furthermore, if they don't cash it out before they die, it would leave more in their estate, incidentally, even if they do cash out before they die. But the other point is they don't cash out at all. They take advantage of the stretch rules relating to the person who inherited, which now is best if it's a spouse. And it's not as good as it used to be for other members in terms of postponing taxes of the recipient. But no question that this is a good example where there's lots of opportunity to do some estate planning, and maybe we could call it even distant prospective planning. That allows one part of the table to get substantially more value because it's consistent with our goals. And that opportunity is more likely to exist on the side of the table of the person who doesn't need cash. And when you have things in cash, often there are sacrifices made in terms of its economic value in various ways. And in this case, depending on whether those assets are sold, there are going to be commissions paid in the short term. We could also make the point that we just made also about real estate for houses. That person who's prospective-minded, you gave the example of this farm, this hunting place. You could also do this with any residence, and that's that a residence that goes into a probate estate is going to get a stepped-up value in real estate. So that's a marvelous thing for the person receiving it. If you have children at that time and there's a divorce and you're thinking, I'm going to leave this to my children, rather than taking the cash or the stocks or other things such as that, if you don't need the liquidity, take the asset that will appreciate in value without taxes while it's appreciating. So in that sense, it has the similarity to a tax-deferred asset such as an IRA. It has that quality. You don't pay taxes as it increases in value. And you may never pay taxes if you die with this asset and now it gets a stepped-up basis. So its new value for your children is the value at the date of death. So all that appreciation that was captured in that asset during the period of time, no taxes will ever be paid on. One other point to be made is even if the asset is sold, and this is another consideration contrasting future versus present, is one's capital gains and the other will be at an earned income rate for many assets, certainly tax-deferred assets. So this is, depending on the rate at the time, 20% or so versus what could be 37%. So it's a much more favorable environment in a lot of ways. But all this represents, we're calling it, as we should call it, we should acknowledge that it has an estate planning dimension. But above all things, it's a very future-oriented dimension, which estate planning really is. It's thinking about your latter stages of life and thereafter. So good estate planning thinks about your needs as you age, those changing, somewhat unpredictable needs, coupled with thereafter. So divorce, regardless of the ages, but especially as one of the parties at least is older, this is a more pressing issue.
Yeah, and even for younger individuals, okay? So let's say individuals who are maybe going through a divorce when they're in their 30s or 40s, it's still a good time to start thinking about that if you haven't started thinking about it, because you've got all the tools in front of you. You've got all the information in front of you, right? Because in a divorce case, we have to talk about assets and debts. We have to talk about your financial circumstances. What's your income? What are your expenses? And so you've already got all that in front of you. So just from a timing perspective, yes, you're going to have a lot of other things on your mind as well, right? You're going through a divorce process. That's not a fun process for anybody. But you can kind of kill two birds with one stone and say, okay, well, I've got all this information already. I don't have to go through and get it all together. Now let's do that planning. Maybe you haven't done a will yet. Maybe you haven't set up a trust yet. Maybe you haven't. I mean, I know it took me forever to put beneficiaries on my retirement plans just because I always had my wife, but then we had kids and I just didn't think about it until the topic came up when we were, talking about some estate planning stuff. And I was like, I really need to do that. If you haven't thought about it yet, that's a good time to do it because, like I said, you have everything in front of you. And that's half the battle, is just getting all of that information into one place so that you can start thinking about, in a holistic sense, what do I want things to look like going forward?
Yeah. And then we have those cases, though, where it actually, probate is going to come up more urgently than others. And it's not just older people, but we've made the case, you can make the case that at all ages, because of the similarity, because of the fact that these issues bear a great resemblance to each other, it only makes sense, regardless of age, to at least contemplate the implications or the opportunities associated with that more distant planning. But now let's shift gears and talk about where suddenly this issue becomes a little more urgent. Yeah. And I guess statistically that would be people, we mentioned where you have two parties that are both older. Mm-hmm. And then you have a party where one at least is older. But then you have people who, there may be cancer, there may be some sort of illness where that one of the parties, either your client or the other party, has been diagnosed with some illness. Maybe it's not been declared terminal. Maybe it's in treatment stages. Maybe there's optimism. But the point is, it's clearly a red flag to your client that, look, I need to keep in mind the implications, not to mention the other client. I mean, it's a red flag to both parties that they need to be thinking about this possibility of one of the parties dying.
Yeah.
And then, of course, there's that statistically less common phenomenon where you just have freak accidents.
Right.
Or stuff that occurs. I'm thinking of a case where we were engaged years ago in a custody battle. This was when I was actively practicing domestic relations. And we had we had a case where the children were younger. There were two kids. We represented the dad. It was a very conflicted sort of case. There was a lot of litigation. Litigation took place over time. Accusations of neglect and abuse. We made accusations to that point. And as we were preparing to go to trial, it was unclear what the outcome would be. And just, I think, the weekend before the trial was to start, the mother committed suicide. No, it wasn't suicide. It was a drug overdose, but they concluded that it was accidental. It wasn't suicide. But still, right. I mean, it was a case where suddenly, all those issues that we were talking about before were off the table. And now suddenly it was estate planning issues. And these people had some assets. So you never know in some cases when that's going. That would fall into the freak category. Nobody expected that.
Unusual, absolutely.
Yeah. But those cases where one of the parties maybe has had type 2 diabetes and they've maybe even had something like an amputation or there are signals right. that potentially in these cases one of the parties may die sooner than it would otherwise be expected based on their age.
Those are difficult circumstances because there are some things that you can do to prepare for that. But it's especially, obviously the ones that are out of the blue, there are things that you can try to do to prepare for that, just being generally prepared with your estate planning goals. But there are other things that you can do if you do have some of those more red flag type scenarios where you say, okay, this is a possibility. You never hope for it, but you always plan for it, right? So when we're planning for these types of scenarios, there's a couple different things that that I've seen come across during my time practicing that people have done to try and address some of these issues in a little bit more of an aggressive way. I can think of a case recently where a party had a terminal illness and they wanted they no longer wanted to be married. There's certain rules in place where if you're married, right, you can elect to take against the estate, right? You can elect against the will. And so they wanted to ensure that would not happen. So what they did was they filed a motion to bifurcate. And what that means is they asked the court to sort of separate the parts of a divorce case. So with a divorce case, there's going to be the actual dissolving of the marriage. That's why we call it a dissolution of marriage. Then there's going to be the division of the assets and debts and custody determinations and child support and maintenance if those are issues that are applicable in the case, but certainly dividing the assets and debts. And so in this particular case, they asked the court to dissolve the marriage prior to addressing the assets and debts because there was some premarital property. They wanted to ensure that was going to go the way that they wanted it to. And because both parties had admitted that the marriage was irretrievably broken, the court actually went forward and granted that, dissolved the marriage, and then they were going to deal with the assets later. Now, there's a question about whether or not that was appropriate. Okay, so I'm not saying that is a fix-all, that is a tool that you can necessarily use.
Well, but in some states that is, though, more commonly.
Yeah.
I mean, in some states it's not unusual to what you call bifurcate. Mm-hmm. So in those cases, often it does make sense if one party wants to go ahead and marry. In this case, it was a really good reason where somebody, if they pass away, I want our audience to understand that if you pass away and there's a marital status, unless there's some postnuptial agreement or something else that would supersede these rules, the other party as a spouse in that status, irrespective of whether a case is pending for divorce, for example, in most states, in many states at least, they have the right to take a certain percentage, whatever you say in your will. So let's say you say in your will, a divorce is pending, and you say, I want everything to go to my children. Well, in those states, then that means, though, that if it's pending, the gavel's not gone down on the divorce of your marriage. In other words, the marriage itself has not been declared dissolved. Then it means at that moment that this woman is every much a wife as she would have been if no such filing had taken place. So she can take in those states a third, could be a half. So electing against the will is a common phenomenon that exists for good reasons. I mean, the public policy reasons is, the law understandably didn't want, notoriously it would be men who would sometimes be angry at their wives and they'd have a will and they could leave everything to their kids or to their girlfriend.
Yeah, the girlfriend.
To the girlfriend. And so you have this wife who may have been without means to make a living, and all of a sudden she's broke. So the law has existed in the Western world for many years that if your status is married and your spouse is alive when you die, then whatever you say in your will, there's this right to elect. So in this case, it made complete sense that this person goes to court and says, I want to bifurcate, meaning I want to first end the marriage, then we'll get to the other stuff later. And lots of states will do that because it's often quick and easy, and it's not unusual. It's unusual in Missouri to do that, but it's not unusual in many states. So you can often get what's called a grounds hearing, where you just have a hearing, somebody gets on the stand and says the things that state requires for a divorce, like in Missouri, irretrievably broken.
Right.
So if they state that the marriage is irretrievably broken, then that was stated under oath. The judge brings the gavel down, they're divorced, and then a date is set to have hearings regarding the division of assets or even custody. So, and there's a temporary order in place maybe regarding those things. So in that case, that saved this person's estate plan, essentially.
Yeah, I mean, it was a big part of what they wanted was to leave this asset to their children. Again, that second marriage, second relationship, they wanted to make sure that was secured. And so they took this sort of unusual but effective tact in their case to make sure that those goals were being reached.
So take a few minutes and talk about about what somebody should do if they're anticipating divorce, or they are during divorce or after divorce, how they need to change certain documents,
Sure.
what the implications can be for their estate planning, et cetera.
Yeah. So the first thing to know, and this is important, is that your divorce judgment is not noticed to third parties. Okay. So when we're not looking at it from an estate planning point, it's, okay, do you have an outstanding credit card that's joint? And you need to let that credit card company know, hey, we're shutting down this credit card. We're no longer going to use it. They no longer have access to it, whatever it might be. But from an estate planning standpoint, if you have assets that were held TOD, if you have assets that are titled jointly, you need to move relatively quickly to make sure that you are changing those to reflect what's in the judgment. Now, some states do have some rules on the books that talk about if there's been a divorce judgment that, what's in the judgment is going to be binding.
Yeah.
And oftentimes in our settlement documents, and again, this is one of those benefits to settling a case, if it is settlable, we can add additional language into the documents. And so we can say, this judgment is binding on the litigant's heirs and assignees and so on and so forth.
And as you point out, though, there are a lot of states that will, maybe half the states, I guess we estimate, that will says automatically, the legislature does, that certain things are changed when the gavel goes down, and it could mean, I guess,
beneficiaries
for QDROs, are they?
Well, so QDROs. With a QDRO, and we say QDRO is a qualified domestic relations order, okay, and it's I'll say it's a special way that we divide up assets, particularly qualified accounts. So we're usually talking about
tax-deferred accounts,
right,
IRAs,
401ks. Technically, IRAs aren't actually required to use a QDRO; they're not qualified accounts. But a 401k, pension plans through your employer, things like that, we use those to divide those accounts up without tax consequence, so that you're not actually, cashing in your retirement and then handing that money over to the other person. You're just dividing it up into two new accounts.
And it prevents the tax consequences from being triggered.
Right. So getting those done is very important, but getting them done right the first time is key, because if it's not done correctly, and there's some considerations too that we'll talk about in a second that go into QDROs and the division of these accounts, but if it's not done correctly, it can be incredibly difficult to go back and get it changed, particularly if it is a later in life individual, once they start drawing off of that retirement.
Yeah. Once it's in a pay status, it changes.
Yeah, it becomes much more difficult to change any errors in there. So some of the considerations, though, that we need to think about when we're going through the process are, is there going to be a survivor benefit? Because the way that it's set up, most of the time you can get there's language in there that talks about if one of the parties, let's say the person who has the account, if they decease before the QDRO gets approved and finalized and everything, the alternate payee, who's the other spouse, they will have a benefit to the extent that they were awarded under the judgment.
So it can be protected, but still it is a third party,
right,
and it does require some legwork to go and get that done. But QDROs, again, qualified domestic relations orders, it's not unusual for it to be the most valuable asset in the marital estate.
Yeah, I mean, real estate and retirement accounts are usually the two biggest assets that we're looking at.
And some people think that it's simply a pot of money sitting somewhere, which it could be. It could be in the form of simply a sum of money sitting in an account, and that is relatively easy to calculate, apart from the other terms that you might have in a QDRO. But as to a traditional pension,
no.
I mean, it depends on how you do the math. If it's a present value of future cash flows based on the lifespans of the parties, et cetera, as you point out, depends. If there wasn't an election to give a survivor benefit, then there's no way that the wife would continue getting paid beyond the death of the husband, or vice versa. I use that example. I'm used to using that example. But But it's important now to know that there is federal law that generally, in order for that guy to put down something that would exclude his wife, she has to sign a consent. So that law has been in effect at least 20 years. So it's very hard for the husband now in a traditional pension to leave his wife out or vice versa because of this rule that now it's required to have a consent form, which it makes sense. It should always been that way, a consent form for the spouse to sign. But anyway, so these are complicated things that can be left dangling if somebody passes away and it's not been dealt with in some sort of settlement agreement or whatnot, and they're still married at the time. But your point is that even after the time that there's a divorce, there's lots of stuff that needs to have been done, and you can't count on the statutes in your particular state to protect you on these things. True, there are some that will protect you from, regarding life insurance. Often a beneficiary clause on life insurance will be changed.
Yeah.
Often provisions in a will will be changed. I think trusts are commonly a provision where you have a beneficiary in a trust. I wonder, though, if it's irrevocable. But
if it's irrevocable, you might have some issues.
Yeah, I think you would. But at least half of you watching this show do not have those protections in your state. If we assume equal distribution of viewers here. I think we looked at this the other day, and there are like 24 states that do not automatically give this protection when somebody dies. So this means if there's a divorce pending or the divorce is completed, both those scenarios, you're vulnerable. So what makes sense is when the divorce starts, you have to talk to your lawyer. Talk a little bit about kind of there's a status quo that comes over all the assets when you file a divorce in most states, and it's to prevent this scramble that sometimes takes place when somebody files. Like they'll scramble for
money
kids.
Grab. Grab the kids.
They'll grab kids off of playgrounds and say, I had the child in my custody when I filed, or after the filing, I guess is more the play. So anyway, talk a bit about the constraints on that.
Yeah, so when you file, generally the court wants you to keep things status quo. Okay, so in terms of, for example, we have some specific statutes that talk about, you can't remove the other party from your health insurance policy.
Life insurance, I wonder.
So life insurance, I haven't had that one come up yet, but the statute, I know it talks about health insurance as the big one. There's some local rules, and this can vary within your state. So, St. Louis County, St. Charles County here in Missouri, different rules for different courts. So some of them have specific rules that say you can't change beneficiaries, you can't change any coverage. So vehicle insurance, life insurance, health insurance, dental, vision, any sort of insurance.
Yeah.
But they all have their own set of rules, but the whole idea behind them is to keep the status quo. So some are more robust than others, but with that being the case, when we're looking at it from an estate planning standpoint, okay, well, I may not be able to go in and change my will immediately once the case is filed. If you're thinking about it, if you see that this might be, you see the writing on the wall, you see this might be coming around the corner, that might be something to preemptively take care of before you're filing.
Yeah.
And it's not, look, that may sound a little bit aggressive, maybe a little bit unfair, but it's from a perspective of when you're talking about your estate planning, you want your wishes to
prevail.
That's right, past your death. And so, we never know what's going to happen, right? There's freak accidents that happen. There's, just crazy things that happen that you may not be able to plan for, but if you take that initial step of, okay, well, I see this coming, what are some things I need to think about?
Yeah, and that's what we want to emphasize here in this advice is at this stage of the conversation, we're really talking about where you kind of see the train coming down the track, or you have reason to believe that one of the parties could very well pass away before this case is over, and depending on which side of the table you're on, you reach different conclusions.
We talked a little bit earlier about postnuptial agreements, or we mentioned it. We didn't really talk about it too much, but everybody's heard of prenuptial agreements, okay? A prenuptial agreement contract that you enter into before you get married, and it's going to set out a lot of terms, what you're going to do with certain assets that you already have, whether or not maintenance is going to be waived, or there's going to be a certain amount that you agree to in advance. You can create a contract to address all those things in case of a divorce, but it's not just for divorces. Prenuptial agreements are actually the reason why they're enforceable is because they're also for estate planning.
Yeah.
It's something where, again, what you're doing with a prenuptial agreement and really in a postnuptial agreement as well.
Postnuptial especially, but go ahead.
Right. What you're doing is you're contracting against the statute. Okay, so every state has its own rules, its own statutes about what's going to happen in case of a divorce or in case of a death. With these prenuptial and postnuptial agreements, you're saying, well, we understand that. So first you got to understand what your state's going to do. So probably good to talk to an attorney at that point. But then we understand what's going to happen, but we don't want that to happen. Here's what we want to happen. And both parties have to be in agreement, right? You can't enter a prenuptial agreement one-sided.
And I want to emphasize that it is true that kind of the same general rules apply to prenup and postnup, but prenup it is often, while it does relate to, as you said, to estate planning, often also it relates to other stuff that people, maybe one person's wealthy, the other's not. But I think you agree with me that when you're doing postnups, really, postnups are generally motivated primarily by concerns about estate planning. I mean, it can deal with some of the same issues, of course, that a prenup does, but a postnup means you're married not after a divorce. It means you're married, and then while you're married, you decide, wait, we want to develop these rules about how our property is going to be allocated. Those are most reliable. I'll put it this way. I think you'll agree. They're most reliable if they relate to estate planning. Now, they can cover anything, arguably, as long as the court later concludes, if called upon, to rule on the validity of it, as long as they're not clearly unfair or exploitive. But on the estate planning side, the court is more likely to uphold it because it is what these things are about. I mean, they're most historically, the most important role that a postnup especially played, but arguably prenups even, if we go back hundreds of years, is to protect the family wealth or, the family estate. So that's estate planning. It's about primogeniture at one time, which means the oldest son would inherit, the kingdom or whatever feudal lands they had. So in this case, it is a good thing to think about even now, where this discussion doesn't really fit perfectly the profile we started with, where we started with people who are confronting divorce, whether it's later in life or not, and what are the implications for their estate planning, and that imagines a divorce actually happening. But this discussion is really, this what I'll call postnup discussion, is really about, if you're older, maybe you want to avoid a divorce, but you're thinking, what about my estate plan? And there are things that are important to me. I have these children from a prior marriage, for example, and this boat has gotten a little rocky, and I'm less confident of its seaworthiness. So you might think, well, gee, does that mean I have to go get a divorce? And the answer is no. You don't have to go get a divorce,
right. But
maybe you do need to go and get a postnup in which you address specifically these issues. And there's lots of ways. This show is not about how to structure those. Maybe we should do a show about that. But it is to call your attention to an alternative to divorce for those of you who are in the position to make the decision. We'll assume that you are the person who's about to file. If you're not, then, of course, this isn't in your hands. But you can still raise it to the other side. Right. So you can still go to your husband or wife and say, look, there is an alternative to divorce if this is your primary concern. So we're going to break this conversation into a total of 3 parts. I think many of you, maybe all of you, watched part 1. That's the reason you just watched this, which is part 2. And I hope that's true. And I hope that you found part 2 as helpful as I think you did part 1. In which case, tune in for our next episode, which will be the 3rd and final episode of this discussion about death and divorce. See you then. This is Life's Third Act. Till next time.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.